Good afternoon, everyone, and thank you all for joining us today for this presentation on custody and visitation issues during the COVID pandemic. My name is Andrea Terry, the Director of Learning for the Maryland State Bar Association, and we thank our Family and Juvenile Law section for bringing together this panel of experienced and knowledgeable attorneys to provide some insight into this timely and frankly urgent topic. Presenting today are Brian Pearlstein, a partner with Brodsky, Renahan, Pearlstein, and Bouquet; Rebecca Fleming, a partner with Turnbull, Nicholson, and Sanders; Peter Markuski, a partner with Guzman, Bernstein, and Markuski. And your moderator today is Craig Borchers, and he is the CLE liaison for the Family and Juvenile Law section and has done a great job putting this presentation together for you today so you can get an idea of what all the jurisdictions are doing with regards to custody and visitation issues. And with that, I will turn the program over to Craig. Thank you.
All right, well, welcome everyone to our program. I'd like to start by thanking Andrea, Chriselle, and Bill from the MSBA. It's been their efforts and abilities that have allowed us to broadcast this presentation today. I, as well as the three other presenters, are all members of the Family and Juvenile Law Section Council for the MSBA. And as we got together and began to plan this program, there were a few things that we sought to accomplish. First, we wanted to evaluate the various orders, administrative orders, guidance statements, clarification administrative orders that have all been issued either by the governor's office or by the Maryland judiciary. So we have reviewed all of those, and we want to speak on the applicability of certain of those orders to the areas of family law. Second, recognizing the uncertainty of the times and acknowledging that we're dealing with a situation in which various counties are all operating at different capacities at present. We sought about surveying the various counties. We have contacted as many as we possibly can, and we hope to report back to you here today on what we have uncovered, both with respect to how the various counties are handling receipt and processing of filings, as well as how and under what circumstances these courts are conducting remote hearings. Lastly, recognizing sort of the practical implications of the uncertainty of today's times. With respect to the current health crisis, school closings, work closings, travel restrictions, even the court closings, all of these factors have implications in the area of child custody. So we are going to evaluate many of these issues that we think important. We also intend to answer a number of questions that the viewers present to us here today. My understanding is if you look at the bottom of your browser, there is a chat function with which you can submit written questions, and we encourage you to do so. We're going to try and follow those questions in real time as best we can. However, we do acknowledge that there is a substantial number of viewers this morning, or this afternoon, excuse me, and we anticipate a significant number of questions. So for that reason, and also taking into consideration the technological capabilities of the four people involved here today, it's more likely that we're going to set aside some time at the end of today's program and try and run through and answer as many questions as we possibly can. But we do encourage you to submit your questions, and we'll do our best to answer the ones we can. So with that, I think we're going to begin with Brian, and he's going to give us an overview of the governor's stay-at-home order that was issued on March 30th, as well as the statement from the Maryland judiciary on matters concerning children and families, which I believe came out sometime around March 25th. So Brian, if you would.
Thank you. Well, good afternoon, everyone, and I hope everyone is staying safe and healthy, and your families are safe and healthy during these really unprecedented times. So there's a number of orders that have been issued across the state. Before I focus on the statement from the Maryland judiciary as well as the governor's order, I'm going to give you a website link. And this website link for the Maryland judiciary lists all of Judge Barbera's orders, the last one being updated yesterday on 4/28. Applicable to your practice, others may not be, but it's a good website to have. And that is mdcourts.gov/coronavirus orders. And again, this will list out all of the orders from Judge Barbera, things that you should be aware of. Additionally, what I would recommend is that you find a way to get the administrative orders in your particular jurisdiction, if not the other jurisdictions that you practice in. These administrative orders are what guide the practice as of today, possibly, and they change from day to day. Obviously, this pandemic has caused changes on a day-to-day basis, weekly basis, and to keep abreast of that, you really do need to be aware of the administrative orders being issued out of your particular jurisdiction or that jurisdiction in which you practice in, so that you have the proper guidance. Would also recommend just reaching out to other practitioners in that particular jurisdiction so that you know what to do and how best to do it. So starting with the statement from the Maryland Judiciary on matters concerning children and families, really the takeaway from is that all court orders are still in effect. So for domestic practice, your support orders, your custody orders are all in effect. And as the statement states, that court order controls. So that is our baseline now until there's a further modification by the court. Additionally, and I believe what a lot of jurisdictions and the judges are adhering to is its really definition for emergencies. And it states that the circuit courts are only hearing family law emergencies where there is a credible risk of imminent and substantial physical or emotional harm to a child or parent. That I've found in contacting various jurisdictions a recurring theme, which is that we are following Judge Barbera's order and how these emergencies are being defined. However, I would caution that from jurisdiction to jurisdiction and judge to judge, the interpretation may be different. And so you'll need to rely upon what practitioners are doing and how the courts are really attending to those orders. So that's the statement from the Maryland Judiciary. The next one that's of real importance is the order from the governor, which was issued on March 30th. And this is what people are referring to as the stay-at-home ordering, which prohibits large gatherings and events and closing of certain businesses, etc. We do know that law firms and lawyers are essential, and therefore we are permitted to travel to and from our offices. There is a further interpretive guidance which defined and set forth what employers should do in providing documentation to your various employees if in fact they are traveling back and forth. This order, essentially is saying you have to stay at home, only out for essential business for particular purposes. And this order is clearly being used as both a sword and a shield by litigants, by attorneys, in terms of when there are access issues and emergencies. And again, this is going to really fall to the local courts to decide how they're handling those emergencies. It does allow specifically for the transporting of a family member, which is interpreted to be taking a child from one home to another. And you'll hear from all of the panel members on our particular experiences and views in terms of trying to work out access issues during this time. So those are the two orders. So Peter?
On those orders or on my topic?
So we're going to go over to Peter now, and he's going to address what was issued originally on April 8th, and if you'll bear with me, was titled Amended Administrative Order on Emergency Tolling or Suspension of Statutes of Limitations and Statutory and Rules Deadlines related to the initiation of matters and certain statutory and rules deadlines in pending matters. And then just last Friday, a further clarification order, which I won't bother to read the entire title of, related to that amended administrative order was issued. So Peter, can you let us know what, if any, application that order may have in the context of family law?
Well, generally what the order does is that statutes and rules, deadlines related to initiation of matters required to be filed, including the statute of limitations and family law matters in most cases, except for certain proceedings to collect child support arrears or alimony after a period of time, there really is no statute of limitations applicable, shall be told effective March 16th by the number of days courts are closed to the public due to COVID-19 emergency order. So basically, if we reopen 45 days later, if you file something on day 46, it's retroactive back to March 16th. So if the statute of limitations in other civil matters had run, or in other instances where the rules mandate that a hearing shall be heard within a certain number of days, that limitation is stayed and for the number of days that it's closed. The subsequent order was interesting. It didn't really modify dramatically what the original order did. First, though, it did make it applicable to all courts in the state of Maryland, which included the Court of Appellate Courts, which I think the initial order, there was some confusion whether that applied to the appellate courts, but the amended order or the clarifying order included those courts in that order. Secondly, there was some confusion about whether there was a requirement that you had to prove that your inability to file was caused as a result of COVID-19 complications. That was taken out of and clarified and says there is no requirement to prove the practical inability to comply. So the statute of limitations are in fact told during this period for the number of days that the courts are closed pursuant to Judge Barbera's order. However, what is not told is, and is more applicable to us as family law practitioners, are scheduling orders are not told, discovery deadlines are not told, expert disclosures designations are not told. So all of those type of things are not told by either the original order or the clarifying order. What I found in my practice, and I think all of us have found, is that courts are being liberal if you file a motion to extend those deadlines, but you have to file the motion. It's much easier if there's a consent by both parties, but you have to file it before those time periods run. And that period is not stayed or told by either of these orders. Does anybody have anything in addition to that? Craig?
What about with respect to answering of a motion that's filed during this time period? Do you think that there's anything that this order affects in that regard?
No.
No.
Answers are still required. The only thing, well, no, I think it's the initiation of the action that the statute or the rules are told. But in an action that's ongoing already, I don't believe those time periods are told.
I agree.
Correct. And it's important, if you are seeking a modification of child support or alimony, that you file and preserve that retroactive date.
Correct.
Thank you. So let's sort of pivot to what we have learned in surveying of the various counties. Becky, if you would, let us know what you have found out with respect to the counties that you spoke with.
Sure. So we're trying to get the most accurate information, the most current information that we can to provide to everyone. Having said that, one of the administrative judges that I spoke with actually referred to this as just sort of fluid. So I'm going to go through several counties, and I can tell you what's happening in them right now. Some of them will be changing next week, and I'm aware of that, and could be changing even going forward. So it's important for all of us to try to remain vigilant and make sure we know what is happening in our own jurisdictions. But as of right now, in Baltimore County is accepting filings. They are ruling on motions that are ripe. They are rescheduling cases that have been impacted by the closing of the courts. They are conducting remote uncontested divorce hearings when there are two attorneys involved. They are also conducting remote pretrial settlement conferences, and they're conducting remote scheduling conferences. They are also starting to conduct remote mediation sessions. So if you have any of those things that are coming up or that you would like to have set, you can actually reach out to the court. I have reached out to Baltimore County to schedule uncontested divorce hearings, and they are hearing uncontested divorce hearings not only that have been moved, that were postponed, canceled because of the court closing, but also new cases. So I have filed new cases, and when you file a complaint and then an answer and it's ready to go, you can actually reach out to Baltimore County and you can have that hearing set in as well. So they're kind of handling both at the same time. Carroll County is accepting filings. They are ruling on motions that are ripe. They are rescheduling matters. They are not hearing uncontested divorce hearings, pretrial settlement conferences, or scheduling conferences right now. And while Peter is correct that scheduling orders are not told, in Carroll County, they've issued an order that actually extends all discovery deadlines by the number of days that the court is closed. So all of the discovery deadlines in Carroll County are extended. We don't know until when. That depends on when the court reopens. In Cecil County, they are accepting filings. They are ruling on motions that are ripe. They are holding remote uncontested divorce hearings for cases that were scheduled to occur during the time that the court has been closed. But they are not scheduling new uncontested divorce hearings. So if you file a complaint today, opposing counsel files an answer tomorrow, they're not setting that in. But if you had one that was supposed to be heard last week and wasn't able to be to go forward, they will schedule that for an uncontested hearing. They are going to start doing remote pretrial settlement conferences and scheduling conferences soon, possibly as early next week, but they're not exactly, I couldn't get an exact date as when that's going to happen, but they are working on it. Harford County is accepting filings. They're ruling on motions that are ripe, and they are rescheduling matters. They are not currently holding any remote uncontested divorce hearings, pretrial settlement conferences, or scheduling conferences. Kent County is accepting filings. They are ruling on motions that are ripe. They are using Skype for Business for some matters, including pretrial settlement conferences, scheduling conferences, and starting next week, I hear, uncontested divorce hearings. Somerset County is accepting filings. They are ruling on motions that are ripe. They have already rescheduled everything that has been impacted by the closing of the court. They are using Skype for uncontested divorce hearings if there are two attorneys. They're not currently doing remote pretrial settlement conferences or scheduling conferences yet, but they are looking into starting to do that. They also have Zoom mediation that's available, and in their court, their mediators are not technically court personnel, so the courts are trying to stay away from Zoom, but the mediators down in Somerset County, they're located outside of the courthouse. They're not actually court personnel. They are appointed by the court, but then they're paid through family services. So you do have the ability to participate in Zoom mediation down in Somerset County. Washington County is accepting filings. They're ruling on motions that are ripe. They are rescheduling matters, and Magistrate Baker is holding remote uncontested divorce hearings. They are getting ready to start remote mediations, but that has not happened yet. And those are the counties that I looked into as of right now.
Thanks.
Anne Arundel County, one thing I've noticed in calling the various counties is there's a vast difference between counties that are on MDEC and those that are not on MDEC. Mm-hmm. Anne Arundel County, who is, of course, on MDEC, filings are still going on. Pleadings are still being reviewed and docketed. Rulings on motions are being heard. Summonses are being issued. Magistrates are doing remote hearings. The court clerk will send you a notice and it'll have a call-in number and a meeting number. And you call in, enter the information, and generally you're all there at the same time, which is kind of bizarre a little bit, but they'll have you mute ones that are not being called at that time. They're doing uncontested divorces. They're doing scheduling conference. They're not doing any contested matters. And as Brian said at the beginning, they will hear true emergencies involving serious threats to children, their health and safety. In Anne Arundel County, you need to ensure that you file your exhibits, if they're not already filed, in advance of your hearing. Child support guidelines, the state statistical form. I've done a number of these, and it's been very smooth. In Charles County, another MDEC county, they are, again, accepting pleadings. They're ruling on motions. They're hearing uncontested divorces and scheduling conferences. Court will send a link to you that you'll enter. They're using business Skype. The magistrate's in the courtroom. You need to, again, submit your exhibits in advance. You can also, if there are two parties in the uncontested divorce, you can waive orally the 10-day exception period for the magistrate. Again, it's just been a smooth process, and they seem to be going overboard. I had a case where there was a pro se plaintiff. I was representing the defendant. He could not get the camera working. He couldn't even get the audio working, but he typed in answers to the questions that the magistrate read the answers to me, and then we proceeded, and the divorce was done. So that actually worked very well without any problem. I just heard from the judge in Charles County, and Calvert County. In Calvert County, again, another MDEC, they are doing divorces, and they're doing scheduling conferences. They're doing everything audio, and they're using something called Court Call. And they're doing that because it's a great connection. There is a mechanism where you can have video, but they're not using it because that's another level of expense. They're also, it's not family law, but they're hearing civil motions that are without witnesses. Again, you have to make sure that all of your exhibits are pre-filed. The magistrates are holding these hearings, and they're doing it telephonically. And they're going through all of their family law cases, even if they're contested, and they're doing basically what Judge Chanley said was triage of these cases, trying to get a status, see where they are, and to move the cases along. In Howard County, which I have to tell you, from all the counties that I contacted, they're doing this thing correctly. They are doing more than anyone else. They use their platform as GoToMeetings. They're doing scheduling and status conference. They're doing uncontested default hearings. They're doing settlement conferences. And they have another feature where if you are in certain areas, there's a problem with access, there's a problem with support not being paid, violation of existing order, or other what they term urgent matter. There's a form on their county circuit court website that you can file, and you can request a magistrate conference call. You fill out in very general terms what the issue is, the various parties, the contact information, and the magistrate will set up a conference call to review if support's not being paid, if access is not being provided, or orders are being, and I haven't found that in any of the other counties that they were willing to do this, or actually had a mechanism that was available to the bar. And the process is on their webpage for the circuit court. And I found that was the most usable of all of them. In Prince George's County, they're not an MDEC case. While they have a box outside the commissioner's office to accept pleadings, which they say they check 2 or 3 times a day, and that they are opening the mail, things are not getting docketed. things are not, unless they're actual emergencies, are not getting ruled on. I've been told that mail is in fact being opened. There are very few clerks that are actually working because of concerns about COVID-19, and it's a very much in flux as to what they're going to do. It's my understanding, and this has changed a number of times, that the current plan is for the magistrates to hear cases from home. That there are 5 magistrates, each will do 1 per week, and that they're going to go through the uncontested docket. Originally, they were using Microsoft Teams to do this. Now it's my understanding they're actually going to use Zoom, even though I don't know if that's been approved. But the litigants are going to be sent a notice when the hearings are set, and instruction to forward exhibits, that the magistrates will be utilizing a program called PaperVision, and all files for the hearings that they're going to hold are supposed to be pulled, the documents scanned, so the magistrates can review the documents and take testimony as necessary. And they will be doing both contested and, pro se and non-pro se. And that's supposed to actually start Monday. But again, that's up and somewhat flexible, and it just depends. But that's what to this date, they've not had those hearings. Queen Anne County, they're another MDEC. And again, they're accepting filings, they're issuing summons. Back up to Prince George County. As far as I know, there are no summonses being issued in Prince George's County for new matters. Queen Anne counties, they're doing remote hearings on uncontested divorce, on scheduling conferences, on settlement conferences. The clerk's office sends out an invitation, either sometimes in Skype and sometimes in another platform called Polycom. You sign in as a guest on these things and enter into that. In Worcester County, another MDEC, they're doing scheduling conferences, settlement conferences, uncontested divorce. The clerk office sends out an invitation, and it's in their platform. They're using Business Skype. They are accepting filings. They are docketing, and they are making decisions and ruling on motions. Talbot County is very similar to that. They're doing settlement, scheduling, and uncontested divorces, and they're also using Business Skype. And those are the counties that I had.
Okay, so the county
came across, Brian. Peter, are you aware of, there's a question about whether or not a protective order hearing set for Monday will take place in Arundel County. Any information on that?
Protective orders are one of the orders that Judge Barbera says will go forward. So, and I did not ask in Anne Arundel County about protective orders, so I don't know the answer to that question.
I had someone ask me about a different county about a protective order, because the Judge Barbera's order says they're not going to be heard until the courts reopen. But then there was I think it was in the district court for Baltimore County, a interim protective order that required everyone to appear, I believe, this Friday for the temporary protective order. And that attorney called the clerk's office and they said, if you have something that says you better be here on Friday, then you better be here on Friday. So I think whatever the order says about when protective orders are going to be heard, the administrative order, if you have an actual order from a court that says that there's going to be a temporary or a final protective order hearing on that day, you probably want to be there just in case. I would rather show up and have someone say, oh no, this has been moved, postponed indefinitely until the courts are reopened, than to not appear on a day where the court is expecting to see you.
Thanks. Brian, what about the counties that you looked into?
All right, so the first county I contacted was St. Mary's County. And so the court is operating on a reduced staff. It is an MDEC county. They're accepting filings. The court is issuing summons. They are not yet doing uncontested hearings. They are doing the emergency custody, SINA, shelter care hearings. Again, for the emergency custody, it's following Judge Barbera's definition of what is an emergency, and there's got to be a credible risk or imminent and substantial physical or emotional harm to a child. They're also doing DV and bond hearings. Allegheny and Garrett counties, again, they're in MDEC counties. They're accepting filings, issuing summons. Now, and I did speak with the administrative judge in Allegheny County. And so what he said was that they were trying to accommodate most matters that are presented to the court by consent, doing it on remote hearings. So whether that are motions, I mean, they're a smaller county and they can handle it, but the attorneys would contact the court, and if it can be done by consent, then they will have those remote hearings. The judge also said they're following Judge Barbera's order. As I said, they have lots of pro se litigants there, but the court is not doing any hearings with pro se litigants in Allegheny County. Some emergency matters, though, he did say were being done in person in the courthouse. And Garrett's following essentially as Allegheny does. Baltimore City. So effective 4/29 today, all motions concerning discovery in civil, non-domestic, and criminal matters are to be filed virtually at, and here's the link, Baltimore City Lockbox, do this again, Baltimore City Lockbox Filings, all one word, at mdcourts.gov. You're also required to physically file your motion as well at 111 North Calvert. That's where all of the civil non-domestic matters are being filed. The court is issuing summons. Court is ruling on motions that are ripe. The court is hearing emergency matters, again, following Judge Barbera's definition of what an emergency is. Court is setting conference call status hearings for trials that are half a day or more. I've spoken with practitioners in Baltimore City, and they're getting notice that the hearing trial date is off, but setting it in for a settlement or a conference call status hearings, trying to move the matters forward. They are doing some remote hearings via conference call. Judge is in the courtroom, and a magistrate would be on the phone. Court gives the telephone number to the parties, and then the parties and litigants and counsel get instructions 2 weeks prior. They have not started default hearings, but they may possibly start default hearings. And as I said, motions are being ruled upon, summons being issued. In Frederick County, the court is issuing summons. Frederick County is an MDEC, ruling on motions that don't require hearings. As of 4/25, the magistrate is starting to take testimony on uncontested matters by telephone only. There's no one in the courthouse. Lawyers have to get their clients on the phone or in their offices. The hearings are being conducted on Thursday and Friday from 9 to 12. You have to submit a line to the clerk requesting the scheduling of uncontested testimony or default, also submitting exhibit, etc. And that's what Frederick County is doing. So Montgomery County, which is quote unquote my home jurisdiction, we are not on MDEC. Summons are being issued, albeit slowly. They're hearing emergency matters, but it must, again, be imminent danger to health or mental status. The docketing of things are happening very slowly. So if you have filed a pleading and you're looking to see if it's on the docket, it's going to take a while. And the way to file in Montgomery County right now, and I will talk about discovery motions, which there was an order that came out Monday night, right after I spoke to Judge Greenberg, the administrative judge, about these matters. We have a drop box. You can file in there. You can also mail. The mail date, your postage date, is the effective date of filing. But I would caution to a snapshot, a photo of the filing date, because we experienced in this firm mailing it on a particular date. However, the actual docketed date was a few days later. And while it didn't affect our filing, it made us decide that we needed to take that extra step in case there's a discrepancy. So be careful about that. The judges are issuing opinions for matters that are under advisement, that in which they were going to issue a written opinion. That is moving forward. Uncontested divorce hearings are beginning remotely for matters already set between May 4th and June 5th. So if it's already on the docket, then there'll be a remote uncontested divorce hearing for that matter. They're hearing emergency juvenile matters, SINIS, shelter care, all falling under Judge Callahan. And so we now have a virtual discovery Dropbox as of April 28th. And prior to that, it was only for track 3 civil motions. Now, Judge Greenberg came out with administrative order that states the following. So this is for civil track 2 and 3 cases and family track 2 and 3, but non 1F, 1J, one family, one judge cases, which are our track 4 cases in Montgomery County. And only for the following matters: motions upon failure to provide discovery pursuant to Rule 2-432, motions for discovery protective orders pursuant to Rule 2-403, and motions to quash deposition subpoenas pursuant to Rule 2510F, together with all supporting memorandum and exhibits and all responsive memorandum exhibits. The procedure, though, is a little different. Both parties have to submit their motions at the same time. And let me go back. If you previously filed a motion to compel, let's say this past Friday, and the time for responding has not passed yet, you are not permitted to withdraw it and refile it. This is only prospectively, at least right now. What Judge Greenberg said is it will only be prospectively. And what happens is both parties have to submit their motions at the same time. So I decide to file a motion to compel today, the 29th. I prepare it. I contact opposing counsel, send it to them saying, hey, I'm filing this motion to compel. You have your 18 days to file your response, or 15 if you hand deliver it. Then when that is prepared, you both simultaneously submit it following the administrative order on how to file it, etc., with any type of supporting documents. You are not permitted as the moving party to file your motion unless you're filing it simultaneously with opposing counsel. I asked Judge Greenberg about that, whether or not on the off occasion that you have an obstinate opposing counsel and they decide that they're not filing it, they're ignoring it. But at least right now, until more these issues are brought up to potentially, I guess, to Judge Greenberg, it's going to have to be a simultaneous filing. And this is the first amended administrative order expanding availability of electronic filing. That's his admin order. Montgomery County also sent out a notice that if you had a case on the civil motions docket, which is not track 4 or orphans or guardianships, these are typically held at 10 a.m. on Monday through Thursday, and it was scheduled to be heard between March 16th and June 4th, and you wish to submit on the papers, you can do so long as you follow the following procedures. You need consent of opposing counsel. You would send the email to the court at mamune motions@mccourt.com. You got to set forth the caption of the case number, the date of the hearing, the title of the motion, and certify that you have contacted opposing counsel, the date and time you did so, that you have consent to waiver of the hearing, and make sure you send a copy of that email to opposing counsel. And then they will potentially rule on the motion. And they will review it without the hearing. Dorchester County is simply following Judge Barbera's orders, and they informed me they weren't issuing any separate instructions or statement other than what's being done by the judiciary at large. So those are the jurisdictions that I reviewed and spoke to the admin.
Thanks, Brian. So one thing we now know is that if anyone needs paper towels or toilet paper, Peter's
stop by Peter's office.
We have been getting a lot of questions about whether or not we can put together a comprehensive chart with this information. I don't want to speak on behalf of the presenters, but I do think we can somehow try and coordinate this information. I don't know the technological capabilities of getting it out to our viewers, but I know if anything, we can at least get it up on the Family and Juvenile Section Council website.
So I think that after this, the Section Council should talk about whether we could put something together and then put it up on our website through the MSBA. So it's available to everyone who either is watching this or just is an MSBA member and wants to look at that. I've also been looking at the questions in the comments, and it's kind of interesting that you guys are all answering each other's questions before we get to them. But I wanted to touch on just a few of them. And first of all, Brian, can you confirm that the email for the Baltimore City Lockbox is Baltimore City Lockbox filings at mdcourts.gov? Is that correct?
Yeah, just 1 second. And while I'm looking, what I will say is while we can put something up on our section website with the various information that we have, remember, things are changing daily. Orders are being issued by the administrative judges in the various jurisdictions, and I really do suggest that you somehow get either on an email list or through your bar association or through that county's bar association to get the most updated information, because it is changing daily. For Baltimore City, and again, this is in civil, non-domestic, and criminal matters. It's Baltimore City Lockbox filings, all one word, at mdcourts.gov.
Okay, thank you. And there was another question: are any courts updating docket info on judiciary case search? So the MDEC, the MDEC counties have to, because that's how everything gets filed. But are the non-MDEC counties doing that, Brian?
Yes,
and Peter?
Montgomery County is, but as I said, it's slow. So Judge Greenberg has limited the number of staff in the courthouse for safety reasons, obvious safety reasons. So it's when they are able to get to it. The same way when the filings are done, they ultimately get docketed and then they'll be on case search.
Okay.
And
there was another.
And Prince George's County, things are not being docketed.
Not being docketed.
Well,
No.
they're being, if they are at all, they're very slowly. They have very few clerks that are actually working because of the health concerns.
Okay. And there was a question, which of these courts are actually available to answer questions about policy via telephone during business hours? I can say that in the jurisdictions where that I was assigned, that I wasn't very familiar with, if I called, I generally got somebody on the phone. And sometimes that person said, I don't know the answer to that question, but I'll give you the number of somebody who could help you, and then I would get a voicemail. But I could get some people on the phone at the various courts. I don't know if that was everyone's experience, but that was mine.
That was my experience in most of the counties that I reached out to.
And there was a specific question about Baltimore County mediation and whether the remote mediation was only being scheduled if there are two attorneys, even though attorneys are still not a part of mediation. And we were lucky enough to have a response to that question by Anna Maria Walsh, who knows best. And according to Anna, Baltimore County is not currently doing mediations in contempt cases, but they will be doing remote mediation in non-attorney and one attorney cases soon.
One other question that I noticed was if there is a single website that has access to all administrative orders for the Maryland courts. Now, my understanding, and Brian, if you could repeat the one in the beginning, that was just with respect to the Maryland judiciary. I believe
that's correct. That you're only going to find Judge Barbera's orders. I don't believe that there's a comprehensive website for various orders, although I would imagine you go on to the jurisdiction's website, whether Montgomery County, PG County, that they should be listed there. I believe Montgomery County is. But typically I'm receiving the admin orders either through our bar association or the other practitioners in various jurisdictions that are forwarding those on to me.
Well, I can tell you Howard County has their policy on their circuit court webpage under
Right.
COVID updates, and you click on that and it gives you the whole policy, including this form if you want to request the magistrate conference. They actually have a form which you then have to submit to the clerk's office.
Does anyone have anything they want to add on jurisdiction specific information?
Oh, I can say that while this is definitely a fluid situation, one of the judges mentioned to me that the administrative judges are actually having a conference call 3 times a week, Monday, Wednesday, and Friday, to sort of all talk to each other, talk about what they're doing and seeing how it's going and what's working. So hopefully, as you know, more and more jurisdictions are doing uncontested divorce hearings remotely and it's working well, that it'll be sort of a domino effect and the other courts will start to kind of follow along. And I have noticed over the course of the last probably 10 days or so that we're seeing a lot more jurisdictions starting to do lots more different things remotely. So hopefully with a little bit more time, they'll be able to get a lot more of this up and running so we can start moving these cases along.
I can tell you from talking to most of the jurisdictions, and if I spoke to the administrative judge, they wanted to move these cases along as much as they could, with the understanding that, you know, a contested case with multiple exhibits, they just don't have the capability of dealing with. But motions that had no exhibits and or no testimony was going to be argument or submitted on the record, most of them we're ruling on.
Okay. Let's go ahead and switch gears a little bit, and we'll get into some of the more custody-specific issues. And I think one of the disclaimers that we want to put from the outset is that a lot of these things are unknowns. We're in a time of unknown. So we're essentially just bouncing these issues off each other as practitioners, offering what we believe the best approach to them to be. And that's sort of what we're going to be doing here. So Becky, recognizing that the stay-at-home order has restrictions on non-essential travel, are there any advisements that you're giving to your clients with respect to custody exchanges and just being out in public and driving?
Yeah, so I think like a lot of us, there was about a 2-week period of time where I spent a lot of time repeating myself over and over again to lots of different clients, telling them that you still have to comply with the order, you still have to comply with the order, you still have to let your ex see the child, and it started to get a lot of questions about what if I don't have an order? What if I'm in litigation and I don't have an order yet? Do I still have to bring my child to go see the other parent even though there is no order? Am I committing a crime if I'm doing that? Because technically, how am I supposed to explain myself in the absence of an order? And those were issues that sort of came up pretty quickly. In a couple of my cases that were in litigation, if the parties were following some sort of a schedule, even if it wasn't something everybody was crazy about and not what they're going to argue for in court, we did do some consent orders where we just said on a very temporary basis during the stay-at-home order, during the coronavirus pandemic, until the earth reopens, some kind of language that indicates that we're agreeing to this now without prejudice to argue for something else later. Here's what the schedule is going to be. With the thought that if somebody got pulled over or a police officer asked them, why are you out? And if you say, well, I'm bringing my son to see his dad. And they say, well, where's the court order saying you're allowed to do that? That they would have that on them and be able to say, here's my court order that allows me to do it, especially if a lot of people have relatives who are helping transition children back and forth for various reasons, and we want to make sure that if grandma's helping to transport the child, that grandma's going to be able to say, here's the court order, I'm just helping my daughter comply with that. I haven't heard of any instance where a police officer pulled anybody over and asked them where they were going and asked for any kind of evidence. But at the very outset of this, we were reading about other countries who were doing just that. And so I felt like if I could, I wanted my clients to be prepared just in case. It's a little different if their case isn't in litigation at all. But frankly, those people are probably just starting their cases. I didn't have anyone who's been talking to me who is not in litigation and doesn't already have a court order. So I don't know how many questions we would get about that. But I think the best practice is if you have a court order, you should comply with it, and you should have it with you in case you need to show where you're going with your child, and somebody asks you that question. So that's how I've handled that, especially in the cases that were in litigation already, just to be on the safe side.
So regarding that temporary or interim consent order that you referenced, did you actually file that with the court, or was it just party signed?
No, filed it with the court.
Okay. Taking it one step further, what if we're dealing with interstate or any inter-county exchanges? Is there anything specific to that? And Brian, I'll direct that to you.
Well, I think one of the things that litigants and potentially attorneys are using is the governor's order to not only to stay at home, but the order also requires that if you do travel out of state, and for those that have traveled on 495, those are with the electronics, you see an electronic sign that says, if you visited New Jersey, Connecticut, New York, you must self-quarantine for 14 days. The governor's order isn't specific as to where, just that if you've traveled outside of the state of Maryland, that you're required to self-quarantine. And we do have cases in which parties are residing, whether it's Pennsylvania, just north of Frederick, or New Jersey. And although I haven't had any cases of that nature yet during this pandemic, again, I think one of the things that you have to do is follow practical and make a reasonable approach and try to work this out with opposing counsel before taking it to the court. I have a matter right now that was filed as an emergency by the other side. My client was going to go to Boston. The father is here. The matter was filed this morning, and the courts have not even responded to us about the motion to shorten time or the emergency motion. We don't know when that's going to actually get done, or if it's going to be considered an emergency. But that type of travel interstate, I think, poses a much greater issue, and there needs to be a lot more flexibility in making the determination as whether right now that's truly in the best interests of the child, and how the court's going to view that. Because the courts are not only going to view these matters if it's not an emergency, if you file a contempt, but it's what's the remedy that you're actually seeking. There was a conference call of sorts with the Montgomery County judges, including Judge Albright and Judge Greenberg, in which the first thing they said was every case is going to be case specific, and it's going to have to be decided on what those specific facts are. But again, if you're seeking 30, 40 days of makeup, that just may not be practical. So that all leads to trying to work something out now that works best for everyone under these circumstances.
I would agree with that as well. I think it's important, and hopefully in these cases, both parties are represented by attorneys, and reasonable attorneys can work out these types of issues. And I was the same thing as Becky, and just would keep reading, and I would send out the judicial advisory on enforce, the court orders, even in the pandemic, are still enforceable and still in place unless the parties agree otherwise. And luckily in each of the cases, we were able to work something out, and two of them, two of the parties were in fact under quarantine because they had been exposed, and their attorneys got them to agree not to have contact with the children during the time period that they were in quarantine. And we worked out some mechanism of giving back that time, not all for 14 days straight, but working it out. And I think it's important that as attorneys, we work these things out, because for the most part, with the potential exception of Howard County, which seems you can have a magistrate involved, the courts are not going to hear these cases at this time. They're not, unless there is at substantial danger to the children while the courts are closed.
You're moving right into our next category, Peter.
And there was a
I wanted to jump in with one point.
By someone that said, my client lives in Texas with her son. Father is here in Maryland, a shutdown state. Father wants visitation. I mean, one of the things that you have to think about is that the self-quarantine. So one, how is a child getting back and forth? Is this a child that, are you going to have the child fly unaccompanied at, let's say, age 11 or 12 on an airplane that has 2 passengers, right? Or someone accompanying. And then when they get here, they're going to self-quarantine for 14 days. How long is the visitation period? These are all practical considerations that have to be given to doing something like that.
And as a matter of clarification, I do want to note that the 14-day self-quarantine for out-of-state travel is actually found in interpretive guidance that was issued by the Office of Legal Counsel on the same day that the stay-at-home order was issued. So it's not directly contained in the stay-at-home order, but within that provision, there is an exception for persons who regularly commute into Maryland from adjacent states or the District of Columbia. So I do think that there's it would be handled differently if we were dealing with a case where someone has a regular custody exchange between Pennsylvania and Northern Maryland, or Virginia and Maryland, as opposed to this Texas circumstance, which we just seen, because I would not classify that as regularly commuting into Maryland.
Right, that's a good point.
And so I do think that Peter sort of got us going a little ahead of ourselves, but one of the main issues everyone's running into is withholding of access. So can you guys discuss, and I'll start with you, Peter, how withholding of access is being dealt with from an emergency standpoint, and also in the future from a contempt standpoint?
Peter, before you answer that question, can I just there's some questions directly to me about temporary orders. And I just want to point out that I don't think you need to file a joint motion for a consent agreement. If you have a temporary consent order that you want the court to sign, I think most jurisdictions, if you present them with a temporary consent order in an open custody case, they're not going to ask you to file a joint motion or do anything other than sign it if they have 2 people who are in agreement on how to handle this, because what they really want us to do right now is figure it out, because they're not going to hear it on an emergency basis. Sorry, Peter, go ahead.
No problem. Back to that issue again. In all of the jurisdictions that I spoke to, if it was a situation where one party was denying access as a result of concern over COVID-19, they were not going to set those in for emergency hearings. The only county that seemed to might have some reaction to that was, again, Howard County, because they had this magistrate conference call availability that I didn't see that anywhere else. We had that wonderful case, at least short live case out of Florida with Dr. Teresa Green, who was an emergency room doctor, and the judge down in Miami granted her husband custody over concerns that the mother of the child could potentially become infected and pass that infection on to their daughter. They had a shared custody arrangement. That was quickly reversed by the appeals court and reset or reinstated the existing custody order, and stressed in that decision that parents need to work these things out. If there are concerns of this, talk, but if they can't come to an agreement, the existing order is going to work. I can tell you that 3 of my clients, after I repeatedly said to them, follow the order, sent me the CNN report of Dr. Green's case. And he said, you told me nobody would do this, which I repeatedly 2 days later sent them the appellate court reversing that decision, saying we're going back to the order. Your really only choice is, if you can't work it out, is ultimately file a contempt proceeding. again, that's not going to be heard until the courts reopen. And, as Brian said, I mean, what relief are you going to get? I mean, are you're seeking reinstatement of the time that you missed spread over a period of time? Are you're using this to change custody? I just don't think a court's going to change custody based on a legitimate concern over the danger to the children. But it's important, as Brian mentioned, and I think as Becky said, these cases very fact specific. You have to look at the facts in your case. There's no blanket situation. The first gentleman who sent me this Florida case, his wife is works on an ambulance, and was sure that she would be infected and infect their child. I basically said, if she's not quarantined or she's not gotten a positive test, I don't think you can, in my opinion, and my advice is not to restrict the child from going back and forth. If the situation was she was being quarantined or she had gotten a positive test and would not come to some type of agreement, a reasonable agreement with respect to this, then I would have to tell you it would be my recommendation that the child not be exchanged.
So let's
So Frederick
a little bit
Well-
further.
is issuing PL orders, PL consent orders. They are signing those during the shutdown. I got that in from Gwendolyn McLeod. Thank you.
Well, I think, our clients are going to come to us and ask us, do I have to comply with this order? And some people might have some fears, and they may be legitimate. They might not seem legitimate to you, but to that person, they might be very legitimate. But I think that the important thing for all of us to remember is if there is a court order, the very first thing you say to your client is, I cannot advise you to violate a court order. I cannot advise you to violate a court order. Put it in your emails or whoever else you're communicating with your client. We can't ever give them that advice. We can tell them, if you don't comply with the order, here's what might happen later. And if this happens, if there was a petition for contempt that's filed against you and I had to defend it, I would say this to defend that. But again, I'm not telling you that you should violate the court order, and there might be a contempt order, a contempt petition against you if you do, and you will have to explain that to a judge later on. So it's very difficult, but I think even if we agree with our clients that maybe they shouldn't let their child go for whatever that reason is, we still can't ever tell them that it's okay to violate a court order.
So Becky, along those lines, and Peter had mentioned that everything's very case specific. What if we're dealing with a situation where the one or the other of the parties is a higher risk individual to contract the disease, whether it be a doctor, a nurse, potentially a firefighter, a police officer? Do you have any thoughts in that arena?
I mean, I give that same speech that I just gave, and I also have said to people that if my client is saying to me, I don't want to send my child because my ex is a doctor, a nurse, a police officer, a firefighter, I'm also saying to them, I don't think there's going to be a lot of sympathy on the part of the bench to denying visitation to the people who are doing the most to keep us all safe and healthy right now. So just the fact that somebody is a doctor, a nurse, a police officer, or a firefighter, that in and of itself, I don't think is going to be enough for a judge to say, oh yes, every doctor, every nurse, every police officer, every firefighter right now until the end of the pandemic should not be able to see their child, and it's completely reasonable to keep all of their children from them. Again, I tell my clients, I'm not going to advise you to violate the order, but I follow with that because, there's a lot of, the news cycle is, 24/7 COVID, right? So you see all these sweet pictures of the police officer husband who's saying hello to his daughter through the glass door because he doesn't want to be around her right now. that's fine. But I feel like a lot of that is coming from intact families who are making decisions, and it's not the people who are getting divorced and potentially using something like this for leverage. And so I think everyone needs to be very careful when they talk about classifying certain groups of people and saying we're just not going to let those entire groups see their kids, especially when they're doing all that they're doing right now for the whole entire community.
Anyone else have anything to offer on that?
The only thing further I would say is I may have slightly misstated when Becky jumped down. In the situation, I give the same speech about the alternatives if you deny a court order. But in the one case I had where dad was in fact had a positive result, I did not say you have to give that child back. I explained what the alternatives are and what the likelihood if a contempt action was filed. Dad was insisting that his symptoms were very mild, but he had been positive. So it's a difficult position for all of us, but I agree with Becky that we should not advise our clients to, I guess we become witnesses in that case. And all of us say, well, my attorney told me I didn't have to do it.
Peter, I didn't say that in response to what you said. I'm just trying to follow the agenda that you're blending all together.
So Brian,
Brian dropped that on me, and Brian wrote me into that, So I understand that they're difficult, And unfortunately, in that case where dad had positive, he was pro se, so I was dealing with him directly and not an attorney. So, those are unfortunately situations that we find ourselves in.
So to Brian, along those lines, how would you advise a client if there is the threat of an infection, whether it be someone that has tested positive or someone that has tested and is awaiting results?
So I think that, if the client and or the opposing party is not going to be practical and reasonable about it, and I did have a case in which there was the ex-wife did in fact test positive, immediately sent the children to the father, my client. She ended up, unfortunately, having to go into the hospital with other complications, but also, fortunately, everything resolved. My client was hesitant to send the child back over until there was confirmation. And, and it's unfortunate because we don't have a standard. We don't have a set agreed upon protocol for if someone tests positive, should they have 2 negative tests, et cetera. There's a lot that goes out, and that makes it a little more difficult to follow, whether it's CDC guidelines or any other guidelines. And again, you have to use common sense and you have to use reason. And in this particular case, she had already received a letter from the Department of Health because she had self-quarantined, et cetera, and she had resolved. And at that time, it was time, although my client wasn't initially willing to have the child go back because there was no reason not to. And notwithstanding the fact that he was being tested and someone else at his home was being tested, and he wanted to make sure they didn't have it. But she had already been tested. So the argument from the other attorney was, well, she's already had it, so she's not going to get it. Well, we all know that that's unclear whether or not once you have it, you have the antibodies and you're not going to get it again. But I don't think that it would stand up well before the court, which is obviously our baseline, and in common sense, not to allow the child to go back because we can create whatever type of hysteria or dangers we believe might exist. But I really think the courts are looking at whether or not there is an existing danger, whether or not someone is positive. So that's in terms of the testing. If someone is symptomatic, I mean, they should, and hopefully there's an attorney on the other side. It's, hey, get tested. I mean, the testing is becoming a little more available, and then working that out, whether or not there's a makeup. I have one right now that is an international case. The ex-wife is in the UK, and while this doesn't have any type of testing, everyone's been healthy. She can't come back to the States to exercise her access because she's afraid she won't be let back into the UK. That if she does contract it here, her healthcare won't cover it. And so they're going back and forth. And now what she wants to do is just simply put a 9 and 11, I believe, on an airplane unaccompanied to fly to the UK. And there's all kinds of things. I think people get to their wits end on it, but I think that again, you have to exercise common sense, and unless there really is an existing danger, I think access happens.
So we've gotten a few questions that are actually interesting. I don't think we contemplated, but that is the reverse of withholding, dealing with circumstances where a parent is refusing to accept the child so that they can presumably so that they can protect themselves from contracting the disease. Obviously, that causes difficulty for the parent that then has the child in their custody. Does anyone have any thoughts or how they would handle that?
Well, you can't ever force somebody to take the time that is available to them. You can file a petition for contempt if time is withheld, but you can't file a petition for contempt because time is not used. But if somebody has shared physical custody and the other person stops seeing the child but is paying child support based on shared custody guidelines, then I would advise that person to file a petition to modify right away, because they can only backdate that child support increase to the date that they file. But they're going to be waiting a while. I mean, that's not anything that's going to be able to be resolved anytime soon in terms of a judicial order.
Speaking of backdating, and another thing that's not on the agenda, but we had discussed, with the filing of a modification for support, does this amended administrative order related to tolling have any effect on the retroactivity date for the child support, in any of your opinions?
I don't believe so. I think it's the date that you file.
I agree.
It's not a statute. It's not a rule that is for initiating an action. It's not a statute of limitations per se. So it's a filing date. And in fact, in a webinar with some judges from Arundel County, it was recommended file your motion.
Mm-hmm.
The only problem that you may have is somewhere like PG County that are not docketing. And, that's why keep track of your filing dates when you actually have dropped it off or postmarked it.
And then lastly, Peter, in the circumstances of people that have active orders, and those orders provide for either supervised visitation at a visitation center or some other form of public place access, a lot of those options aren't available right now. How would you handle one of those situations?
Again, the access should go forward, and regional people again can agree in some mechanism to have that access. The supervised visitation centers are not open. Some of those are in churches that are closed as well. I have a number of orders where the visitation takes place in Annapolis Mall or takes place in Columbia Mall. And of course, they're not open as well. You can't get into them. I would try to work out some other access in a park maybe that's open, even though a lot of parks are closed, or something along those lines. I would do everything possible to provide the access, the level of access that's provided in the order. I don't believe just saying, well, it says Annapolis Mall is closed, no visitation. I don't think that's an appropriate response to that request. I haven't had one of these problems brought to me by one of my clients yet. I had one that was Montgomery Mall, and the parties worked it out themselves. And my client just called me up and said, "Do you think this is okay?" And I said, "Sure, but we need to confirm it in a communication via either email or text or letter, saying this is to document our agreement that we're agreeing to 3 hours, in Rock Creek Park at this location. I think any changes I think that the parties agree to, I would recommend you provide some type of email or text message or whatever to document what the two of you agreed to. Oral contracts, oral modifications are valid until they're not. And, then you get into a question is, does judge believe one person or judge believe the other? But if there's an email or there's a text message, I would seek confirmation, but that's not essential. That would be my recommendation.
Does anyone have anything to add to that?
I mean, I think Judge Barbera's administrative order regarding custody orders is pretty clear that those kind of situations, the supervised visits, the public place access provisions, the parties will need to figure a way to come up with an agreement between themselves right now, because the court is not going to hear that issue. I actually have a public place access provision, and the parties have not been able to resolve that, but there are still some places outside where that parent can visit with those children, and it's been happening, but there's really not a lot that we can do other than try to negotiate something for our client. And there's I think a real heightened sense of concern over what are we going to do about this? What are we going to do about that? But a lot of what we do always, pre-pandemic and after pandemic, are going to be visitation issues that are terrible on paper, and we have to wait until we have a judge available to hear us. But I think that the supervised visitation actually is more of a problem than the public provisions because of the social distancing requirements and the fact that you're not going to find somebody who's going to supervise the visit. The visitation centers are closed and the supervisors aren't essential. So I think the workaround there is even more complicated for these people to figure out, because generally supervised visitation exists because there's some potential for abuse or there's been exposure to substance abuse. And how do we resolve those issues in a way that makes everyone comfortable and keeps the children safe? And there just might not be a way to do it. And so our clients should be prepared to explain to a judge later that they didn't think there was any way to keep their children safe, to make any adjustment to keep their children safe. And that's, they better be ready to be able to prove that and convince a judge of that.
Anyone have any closing remarks? Any questions that they've come across that they think they could answer?
Go ahead.
Just one thing that I did not mention, and there is a comment that for Prince George County at their Dropbox, there is a stamping machine where you can stamp the original before you drop it in, as well as stamp a copy. I don't know if Montgomery County on their Dropbox has the same thing, or Brian.
Yeah.
There's one question. What if a parent is at high risk because of health condition and the other parent has a high risk of exposure? I think, again, if the question is really, if somebody with type 2 diabetes comes to you and says, I don't want to send my child to visit with the other parent who works in a grocery store because of their exposure at the grocery store, I think if that's the only reason you have, then you're going to be having to explain to a judge why the other parent doesn't get the kid all the time if we're just trying to protect you. So I think we need to be careful in terms of assessing which person's risk is more important when we're talking about risk to the parent and not the child, because this fact doesn't say to me the child's at high risk, but that the other parent is high risk. So again, if there's a court order, I would tell my client not to violate it, but I would be cognizant of the fact that when we're talking about risks and you're weighing those things, that somebody is always saying there's a risk and so the child should stay with me. But the converse of that frequently is there's a risk and the child should stay with me. And so how do we decide which parent wins 100% of the time during what could be months longer of a pandemic? I think we need to be careful about that.
And I just want to make a correction. Montgomery County does not have a time and date stamp when you put into the Dropbox. The clerk is the one, when she pulls it, stamps it.
All right. Well, any other closing comments? If not, we'll go ahead and sign off.
I want to thank everybody who is viewing, and especially the people who are asking questions and providing comments. I've presented at these seminars multiple times. I've never done it when I can't actually see the people that I'm speaking with and see how they're reacting. So I wasn't really sure how this was going to play out. But I really enjoyed the fact that everybody was still sort of reacting in some way and that I could actually see it. So thank you all for participating with us today. I really appreciate it. And thank you to Brian and Craig and Peter. It's always nice to see you guys.
All right. Thank you to all of you. Stay safe, everyone. Thank you.
All right. Take care.
Bye.
Bye.
Thank you all. Thank you, Craig, Brian, Becky, and Peter, for taking the time to reach out to all the jurisdictions and share your findings with us. And we thank the MSBA Family and Juvenile Law Section as well. Stay safe, everybody.